court draw near and you shall be heard. God bless the great state of Ohio and this honorable court. You may be seated.
Good morning. Today's October 14th. We're having court on Tuesday instead of Mondays, which we usually do. But yesterday was a holiday, Columbus Day. So we have some reviews to do for people who are working on court orders. When your name's called for that, come up to the table to your right. If you don't get called and you think you were supposed to be here today, go check in with the clerk. Or if you missed a hearing before, you won't be on the docket. You got to go check in before they'll put you on the docket. Call the reviews.
Linda Carpenter, Andrew Carr, Jessica Christian, Misty Dotson, Susan McCann, Melissa McCarty.
Linda Carpenter, 231792. Linda Carpenter. Linda Carpenter has been called, does not appear, does not finish with her case. So there'll be a bench warrant for failure. Andrew Carr is by teleconference. He's at the counseling center. And Mr. Tarvin is here from the counseling center. Case number on this is 24-7.
May I approach, Your Honor?
Yes. How are you, Andrew?
I'm doing good. It's probably okay.
I didn't understand what the last thing you said.
I just started a regional academy at the college.
Oh, okay, good.
That's good.
I'm reading your report. Okay, it's a good report. You're doing what you're supposed to be doing. And Mr. Tarvin had told me that it's possible that you and your wife will be going back in the family program.
That's what I was told this morning, that they were going to entertain the discussion now that Rainey's getting ready to go into transitional.
So that means you would be there, and you're willing to do that?
Absolutely, I want to do that.
Okay. All right, great. I'll put you and your family back together with your wife and your baby. And, okay, so far so good. Let's make it work this time. You're on the right track. I'll see you back here in about a month. So let's see. What the time frame is going to be on that, the date. Okay, let's do exactly 1 month, November the 14th. Hopefully by then you'll be back together with your family.
Yes, Ron, thank you.
All right, good job. Keep it up.
Thank you, Your Honor.
Thank you, Mr. Tarver. Jessica Christian, 22-2505, 19-255. 1835-66. Okay, are you going to be able to do this?
Yes.
Or? Okay, great.
And I was wondering, do I still come back here every month to make that payment too if I'm doing it that way?
That's for a judgment.
Yeah, that's
Somebody got
for
a
the-
judgment against you for, did you have a wreck where you
Yeah,
caused
that's,
damage to somebody else?
that's what I owe still.
Do you need to have these?
It would be helpful probably to put that in the file. Yeah, this doesn't have anything to do, what you owe here is fines and court costs.
Okay, the whole 5,000?
Let's see if there, yeah, now on 22-2505, there was restitution. So if you pay it that way, you won't have to pay it here.
Okay,
So the only thing you have to pay here would be your fine and court costs.
okay.
you'll need to bring with you proof of payment, so.
Okay.
Because what happens in Ohio, if you damage somebody else's vehicle or injure them and you don't have insurance or a way to compensate them, and that gets filed with the Ohio BMV, you get a suspension for that because you haven't been able to pay their damages.
Right.
So this law firm is telling you if you pay them, they'll lift the suspension on that.
Great.
If you have other suspensions, and I don't know if you do or not, that may not get your license back. And the other thing you need to be aware of is that even though they say they're lifting the suspension, they're not able to actually lift it. They can just lift what they're saying. The B&B has to reinstate you. So what you need to do is call the B&B and say, I understand my judgment suspension is going to be waived. What do I have to do to get my license back? Because they'll probably want a reinstatement fee. That's probably all you have to do, but it's up to the B&B. B&B issues license. And actually, where do you live now?
South Point.
Okay, you can either go to Proctorville B&B or Ironton B&B and walk, if you want help.
Yeah.
You're supposed to be able now to walk in, because they can pull up on the screen your driving record and kind of walk you through it.
Okay.
That's a fairly new thing. Used to, they wouldn't do that. They're supposed to do that now. I'm sure they're very happy about them putting that requirement on, but they're supposed to help you walk through what you need to do to get your license back. Or you can call the B&B in Columbus, but you try to call, it's really hard to get through.
All right.
Okay, you understand what you need to do?
Yes, sir.
Are you paying anything on your fines?
Yeah, I'll pay 20.
Okay. All right, see the clerk to make a payment on your fines, and I'll set your next hearing for a month out, November 14th. Okay, good luck on getting your license back.
Thank you.
Misty Dotson, 23706. Okay, this is ODI, community services completed. Okay. Okay, very good. You got a report from Marshall Health. That's good. Can you pay anything on your fines today?
Fine.
Okay. See the clerk, November 14th is your next hearing,
Thank you.
9 o'clock. Susan McCann, 21134, 2123. Okay. Good report, you completed an inpatient with Lawrence County Recovery.
Your Honor, if I may, I have a note also. Ms. McCann was ordered on 9/5 to have some community service done before her next hearing. I don't know that we knew she was inpatient or she could do community service at the time.
Okay. All right, so you can do it now?
Yeah, I've been working with Lou Piles at the Lawrence County, the Hana Tunnel.
The what?
The Hana Tunnel with
Oh.
Lou Piles.
Okay, we usually accept that, I think. So get us something from her with the hours that you work.
Okay.
Get it to Mr. Cooper or Mr. Major to get credit for
Okay.
your community service hours. Okay, November 14th will be your next hearing, 9 o'clock. Are you paying anything on your fines?
I've paid $50 so far.
Did you pay something this morning?
No,
Are you going to pay anything this morning?
I can.
Yeah. How much?
25.
All right. See the clerk to make your payment. Be back here in a month, November 14th.
All righty, thank you.
Mistia McCarty. She's at Focus. a report from Focus. So we're doing an outpatient now.
No, she's still
She's
inpatient.
inpatient, okay. Okay, and she has a monitor, I believe.
Yes.
Keep it, or?
This was actually put on by Judge Finley.
Oh, okay, so it's not up to me. So it'll stay on until Judge Finley takes it off. So you're getting monitored by common pleas then too? All right, so we'll go further. Since you got another court watching you, I don't think I need to have you come in as often, so we'll go 2 months before your next hearing. We'll make it the 15th of December. Will be your next hearing at 9 o'clock. Okay, good job so far.
Thank you.
Michael Miller, David Moore, Elena Pennington, Amber Sloan, Alexis Destiny Smith.
Michael Moore, 242113. I'm sorry, Michael Miller. I just read it. Michael Miller.
Yes.
Your Honor, he was here Saturday, it was the community service, the last two.
Okay. Okay, he's got a good report from Health Recovery Services. He's now finished his community service. You're making a payment today on your fines?
I made one as of this morning online,
How much was that?
$25.
Okay. And you are working now, right?
Yes.
Mondays or Fridays for your hearings?
Fridays would work best if that's okay with you.
November 21st.
Okay.
That's a Friday. Friday before Thanksgiving. November 21st, 9 o'clock. David Moore. Where's where I got the Moore? David Moore, 25135. Okay. Okay, based on the report, I wanted to do a screen today, so let's get a screen today and come back. And go see Mr. Major to get a screen done. Elena Pennington, 16-1593. Yes, she's at Lawrence County Recovery. Thank you. Okay, good report. So, you're just paying off your fines now. Do you have a
Right.
payment on your fine?
I do not. I haven't been able to go back to work since I had my back surgery.
Okay. When are you,
I go this Friday to my
see
neurologist.
if you get released?
Yeah, yeah.
Okay. All right, we'll work with you on that. Your report's really good, so I'm gonna go in December before your next hearing.
Okay.
December 5th, first Friday in December, 9 o'clock.
Thank you.
Okay, keep up the good work.
Thank you.
Amber Sloan, 24-725. She hasn't done anything on her case, so I guess it's not a big surprise. She didn't show up for a hearing either, so she'll get a warrant for not appearing. Alexis Smith, 193668. She's on teleconference. She's at the counseling center. Okay, it's a good report. It says you're compliant. You got to get your community service done. You got 5 days of community service and your fines. So how are you going to take care of those?
I just got a job 2 weeks ago, so I can start paying on my fines. I can pay like $10 today, but then every 2 weeks I can start making bigger payments.
Okay. I'll set you.
And, sorry, go ahead.
That'll be acceptable. Go online, make your $10 payment, and I'll set your next hearing 1 month out, November 14th.
Okay, well, I wanted to ask you or bring it up to you that my counselor here talked to my probation officer about me doing outpatient, because last time I had court, you said that as long as the counseling center approved it, that you would approve it. And they were talking to my probation officer, and they said as long as I had been in treatment for 6 months, that I was eligible. And between the 3 places I've been, like graduating OCP, I've been here for like 8 months altogether. So they're trying to get the documentation for that together to send to my probation officer to get that approved.
Okay, well, that's not the way it works. We will go with whatever the counseling center recommends. If they say you're ready for outpatient, then that's what will happen. If they say you still need to stay in inpatient, then you stay in inpatient, so.
Okay, well, they said that I'm ready, and they'll send the stuff to my probation officer saying that.
All right, he's in the courtroom right now.
Yeah, I'll touch base with him, Your Honor, and if that's the case, then I'll get you something on paper.
It's the treatment team's
Yes.
responsibility to decide what your treatment will be, and we'll go with that, so.
Yeah, that's my standing order, Your Honor, too.
All right, talk to your treatment team. So,
Take
your
care.
next hearing is in a month, November 14th at 9 a.m.
Thank you.
Okay, well, thank you.
You're welcome.
Bye.
Okay, we're going to start the arraignments now. So, arraignments are new cases or old cases where you missed a hearing or got a warrant issued or a probation violation. So when your name is called, come up to the table to your right, just like the previous people did. Stand there. I'm going to go over the charge with you. You have a right to remain silent. You don't have to say anything. If you do make statements, everything we say in the courtroom is being recorded, including the video. So there's a video of you saying what you're saying. So it's hard to deny later. So if you get up and admit something about your case, you're going to be stuck with that. So you don't have to say anything. If you have questions or if you want to talk to a lawyer, it's better to talk to the lawyer off the record. Don't make the statements in the courtroom, because what you say in the courtroom can be used against you. What you talk to a lawyer about off the record can't be used against you. You have a right to have an attorney, to have one appointed for you if you can't afford one. You have a right to bail and to make the state of Ohio prove any charge against you beyond a reasonable doubt. If you enter guilty or no contest, you're waiving those rights I just explained that you have as a defendant. Don't waive your rights if you don't understand what's happening, if you're confused, if you want to talk to a lawyer, if you want to try. Any of those reasons I just mentioned, do not enter guilty or no contest. The safest plea is always not guilty. You can change your plea later if you after you talk to a lawyer if you decide you want to enter a guilty plea. Call the first case.
State of Ohio versus Shauna Short, case number TRC 252580, A and B.
Ma'am, are you Shauna A. Short.
Yes.
Ms. Short, it's alleged that on October the 9th at 10:04 a.m. in Rome Township, you were driving a vehicle while you were under the influence of either alcohol or drugs or a combination of those things. The state's alleging that you refused to take any tests. And they're also alleging this would be your first, if you get convicted on this, it will be the first time you've been convicted on this charge. So on a first offense, the maximum you face is 6 months in jail, $1,075 fine, and a 3-year license suspension. That's the most the court can impose as a penalty. There is a minimum. Most charges don't have a minimum. This one has a minimum, but I can't go below, set by the legislature. The minimum you can get if you're found guilty is 3 days in a treatment program, $375 fine, and a 6-month license suspension. You're also charged with driving outside of your lane left of center. That's a minor misdemeanor. The maximum penalty is $150 fine. So you have 2 charges. Do you understand the charges you face? Do you understand the rights I explained defendants have?
Yes, sir.
How do you plead to this charge?
Not guilty.
Do you want a lawyer appointed to represent you?
No, I want a lawyer.
Do you want one appointed? Do you have the money to hire a lawyer?
Yeah,
You want to hire your own lawyer?
yeah.
Okay. Well, let me tell you when I'm setting cases and see if that's enough time for you. Probably wouldn't set your case any earlier than November 3rd. And you think you can have a lawyer by then?
Yeah.
Okay, I'm going to set your next hearing for November 3rd. That's the first Monday in November. It'll be a pretrial at 10 o'clock on November 3rd here back at this court. I'm putting down to hire a lawyer. I'm going to let you sign a signature bond. You're going to have to go get fingerprinted at the jail. Mr. Cooper will bring you a form to take with you back to the jail to get fingerprinted. She can sign a $1,000 signature bond. I'm entering a not guilty plea for her. There is an automatic license suspension in effect on this since under Ohio law, if you refuse to take tests, your
I
license-
tried to take it,
Well,
but it was broke.
They put it down as a refusal, so you need to talk to a lawyer. They can file some, if there's a reason that the automatic license suspension should be lifted, your lawyer needs to file a motion to have it lifted. But as of now, since the trooper put it down as a refusal, it goes into the B&V. I didn't suspend you, but the B&V is going to suspend you.
Okay.
Do you have any questions?
No, sir.
Okay, be back here November 3rd unless your lawyer says they made arrangements for a different date. They may be busy on that day, so you come when your lawyer tells you to, if it's different than November 3rd. But tell them the date the court gave you.
Okay.
Any questions, ma'am?
No, sir.
Okay, that's all.
State of Ohio versus James Markham, case number TRC 252636, A, B, and C.
Sir, are you James Markham?
Yes, sir.
Mr. Markham, it's alleged that on October the 11th at 11:38 p.m. in Fayette Township that you were operating a vehicle under the influence of alcohol, drugs, or a combination of those things. There doesn't appear to be a test. There's not one indicated.
No, sir.
Okay, so you didn't mark refusal, but in the report it says there was a refusal. So that, I don't know, the B&V probably won't give you an automatic license suspension like I mentioned to the last person because it's not marked on the citation, but that's going to be an issue that needs to be resolved, whether it was a refusal or not. But I can't resolve it today. Okay?
May I say something, sir?
Well, here's the warning I give you.
I
Remember what I said. What you say here in open court is on the record. It can be used against you. If you have any question whether it's going to hurt your case, you probably should talk to your lawyer off the record
All right.
about it.
Yes, sir.
okay?
Yes, sir.
Now, do you still want to say something?
No, sir.
Okay, that's the smart play. Is talk to your lawyer, because that's privileged. What you say in open court is not privileged.
Yes, sir.
Okay, so you have a first offense, OVI charge. We've got this whole issue about whether there was a refusal. There is no test, apparently. It's not indicated there was a test. On a first offense, the maximum is 6 months in jail, $1,075 fine, 3-year license suspension. The minimum is 3 days in treatment, $375 fine, 6-month license suspension. And you understand that
Yes, sir.
charge and the possible penalties. You're also charged with having a headlight out. That's a minor misdemeanor, maximum penalty, $150 fine. And a turn signal violation, that's also a minor misdemeanor, maximum penalty, $150 fine. So you've got 3 charges. Do you understand the 3 charges?
Yes, sir.
And you were here when I explained defendant's rights?
Yes, sir.
You understand those?
Yes, sir.
What plea do you wish to enter?
Not guilty.
Do you want to be considered for a court-appointed lawyer?
Considered, like, if I can't afford one, then one will be appointed to me? Well,
Correct. I have to ask you about your finances. If you want to be considered for a court-appointed lawyer, I have to ask you about your
I can
finances.
afford one.
If you don't want to be considered, I don't have to ask you, because you're going to go hire your own lawyer.
all right. I can afford one, yes.
Okay. I'm entering a not guilty plea for you. I could set this as early as November 3rd or later, give you a little more time if you think you need it to get a lawyer.
A little bit more time, yes, sir.
Okay. Let's go exactly a month. You think you can get it in a month? That's the 14th of November. November 14 will be your next hearing. It will be a pretrial at 10 o'clock. He can sign 1,000. No, I'm sorry. He's got a bond up, so we'll just continue that bond. You've already posted the bond, so it's continued. And I'm going to put down you will hire a lawyer.
14, yeah.
Any questions, Mr. Martin?
No, sir.
Okay. I do not believe you have an automatic license suspension because of the way the citation is filed, so you should not be suspended as of now.
Thank you, sir.
Okay. See you back here November 14th unless your lawyer tells you a different date.
Understand. Thank you.
You're welcome.
State of Ohio versus Jerome J. Starr, case number CRB 23226. You're Jerome J. Starr.
Yes, sir.
And Mr. Starr, it's alleged that on December the 2nd of 2022, at 10:18 a.m. in Rome Township, you provided false information while checking a deer in for harvest prior to purchasing a second deer permit. So that's alleged to be a violation of the revised code, a 3rd-degree misdemeanor. Maximum penalty is 60 days in jail and a $500 fine. Do you understand the charge?
Yes, from what you said, yes.
Now, I see there was $200 paid back in May of 2023, but it appears that you did not come to court for the arraignment initially.
Mhm. Yes, I paid the whole fine. I forgot about the court date, but I did call in and pay the fine.
Okay, I'm not really sure how that got handled, because this is, an M3 is not something, like speeding tickets, you can just forfeit a bond and not appear,
Right.
but this is an M3, you have to appear on that, so that I don't know how the
Well,
money got paid, but anyway, there's a $200 credit on this case, so,
Was that not the whole fine?
no. There was a bond set of $150, looks like, so I think they just applied it as a bond.
I thought I paid the whole amount on the ticket.
So, well, if you thought that, why are you here today?
Because, well, I didn't know anything was even going on. I mean, it's been 3 years, and
one of my guys got pulled over my van, my work vans, last weekend, and they told him that I had a warrant.
Okay.
I'm like, what? So I called in, and I called that day. I called the sheriff's office, and the sheriff's office people I spoke to there said, yeah, we got a warrant, but it shows you paid your fine. And then they told me to call here that Monday morning, so I called in, and court was closed yesterday, so she told me to come in today.
All right. Okay, so how do you want to plead to this charge?
I mean, it's like 6 months in jail while I'm looking at.
This is a third-degree misdemeanor, so the maximum is 60 days in jail, $500 fine.
Okay.
It's not 6 months.
Oh, okay, I'm
60
sorry,
days.
I'm sorry. So what's the minimum if I,
There is no minimum on this.
yeah, I'll probably plead not guilty.
Okay, I'll accept your not guilty plea. I take it since you have people working for you, you can afford your own lawyer.
Yeah, I'll
Okay.
definitely get my
I'll
money.
enter a not guilty plea. I'll set it for a pretrial. November the 3rd or after, you want it set for a pretrial.
What was that date now?
November the 3rd, I'm setting pretrials November the 3rd or after that. So
After that, if you could, please.
Mondays or Fridays?
Mondays.
November 10th?
That'd be fine.
Okay, November the 10th will be your next hearing. Be a pretrial at 10 o'clock. I'm going to put on this, you will hire a lawyer. Okay, I'm going to treat the $200 that you paid, since there was a misunderstanding about it, as your bond. And in addition to that, I'll let you sign a $1,000 signature bond. So what that means is, you're basically signing an IOU that says, I promise to come to court when I'm ordered to, or I'll pay a $1,000 penalty for not showing up. So the 200 would be forfeited, which may have already been forfeited since you didn't appear previously. Plus you owe another 1,000. So just come to court, you won't have to post any more money, get this taken care of. Next hearing is November the 10th, 10 o'clock.
Okay.
Your Honor, will he need to be fingerprinted?
I'm not going to make him go on this. So.
I'm not going to.
Next hearing, November 10th, unless your lawyer gives you a different date.
Okay, thank you.
You're welcome.
State of Ohio versus Cammy L. Thompson, case number TRC 25588.
Okay, this was apparently, you failed to appear for hearing in traffic court?
Yes.
Okay.
I was sick, I called in.
Okay, you did make a $50 payment on you had a speeding ticket conviction, you didn't appear, so it looks like a warrant got issued.
I called that morning because I had been up all night sick. She said, just show up to this date.
Well, that was back September 23rd, right?
Yeah.
Okay, are you paying anything on your ticket today?
I'll pay 10, then I get paid Friday.
Okay, I'm going to set it back on the traffic. Is he doing some reviews on the traffic court document?
Yes.
Okay. You know what the dates are?
The next traffic court is tonight, so it'll be
Yeah.
28th.
28th.
No, wait a minute, I got the wrong.
Today's the 14th, so
Yes,
2 weeks.
28th.
Okay, I'm going to set your next hearing, October 28th, 4 p.m. here at the court.
All right.
If you get it paid before then, you don't have to show up.
Okay, thank you very much.
You're welcome. Withdraw the warrant.
Ready for pretrial, Your Honor.
Pretrial.
State of Ohio recalls David W. Moore, case number TRC 25135, A and B.
Pretrial. Anyone's got a court case, you can courtroom now.
Okay, it's a good screen, Mr. Moore. That's good. All right. So good job. Keep up with your sessions at RRS. You gotta get your community service done.
Yes, sir.
I'm making a payment today.
I can't today. I get paid this Friday, so I can always come in and make a payment now.
Well, look, you've done pretty, you had a second offense OVI,
Yes, sir.
right?
Yeah.
Okay. Mr. Hill, it'd be good for you to hear this too. You know what the legislature says on second offense OVI? I've got to give you 10 days in jail. That's the minimum.
Yes, sir.
Mandatory penalty. Okay, of late, what's been happening is, I went along with it because I kind of agree. Rather than make somebody go to jail, if they'll do more long-term treatment and get over their substance use problem and not have any further substance use problems, that's a better result than them sitting in jail for 10 days.
Yep.
So, you pled guilty to this, and what I did was I said, and it went on the record, it was filed on August 29th. So we're more than, we're a month and a half into this.
Yep.
Your report from RRS is not exactly sterling. They said you had some weeks when you were non-compliant. Now, your screen is good today, so that's a good thing. You've paid 0 on your fines. 0. And what I said was, okay, I'm going to let you see how you do. And I need excellent performance from you not to give you the 10 days in jail.
Yes, sir.
Because if this guy right here didn't agree with it, if I did this on my own without his agreement, not giving you the 10 days in jail, he could appeal the decision and go, we have a court of appeals, 14 counties, the 4th District Court of Appeals. Automatic reversal. I get reversed, they send it back and say, you gotta give this guy at least 10 days in jail.
Yep.
So you're skating on thin ice here. You need to come in and blow me away with how good you're doing, and you're not doing it so far. You've paid 0 on your fines. You've done 2 days of community service in a month and a half. That's not getting it done. You need to act like you're scared of going to jail. Have you been in our jail?
No, sir.
I've never spent the night there. I've visited a few times. It's a scary place. It's built in the 50s. And a lot's been done to it since the 1950s. You do not want to go there for 10 days. I wouldn't want to go there for one night. So start acting like I don't really want to go to jail.
Yes, sir. I'll make sure I get
So
on top
next
of it.
time you come back in a month, I want to see outstanding performance. Like you're not, I know you're working, but are you, how many days a week are you working?
Well, I had to put work on the back burner that way I could get caught back up with my RRS. Got behind there for a minute because I just started working.
How many days a week are you working?
Well, right now it's only down to maybe 2 or 3, so.
You should be out here on your off days doing your community service. What are you doing, man?
Trying to take care of my family. I mean, that's.
Well, wait a minute. Okay, let's go back to the original. Let me pull your ticket up. See, you want to use the family thing. 3:24 in the morning. Was your family with you? How many kids you got?
Have to.
Did you have your kids with you at 3:24 in the morning when you were out and got this OVI conviction?
No, sir.
Don't use your family. When you could go out and get an OVI without your family, then don't use your family for an excuse why you're not doing what you're ordered to do. Okay, I'm not going to give you a month now. I want 2 weeks. That's one of the problems with this country now. Everybody's got an excuse why they don't do things. I don't want excuses. I want performance. Or you're going to jail. Do you understand me?
Yes, sir.
You should probably go today. I'll give you 2 weeks, and I want to see some scared performance.
Okay.
Well, I'm not even going to give you 2 weeks, because 2 weeks is a Tuesday. 13 days. Well, wait a minute, I'm not going to be here that day, and I want to take care of this. So it's going to be the 31st. October 31st. You're going to be back here. And I'm going to be blown away with how good you've done between now and then. Right?
Yes.
Or you're going to jail. Bring your toothbrush. I don't even know if they let you brush your teeth in jail. Hopefully they do.
State of Ohio versus Samantha Bryan, case number CRB 584, Mr. Morgan's case.
Judge, I believe that there's a cross-filing involved here.
Ashley Ferris is the cross-filing.
State of Ohio versus Ashley Ferris, case number CRB 25595.
Okay, she's not wrong.
And this is, Mr. Smith's case is Ashley Ferris. Mr. Morford has Samantha Bryan. 3 trials.
She'll drive one or two conditions. You pay the court. Pay whatever it costs for her.
I didn't break her finger. She didn't shoot me.
She broke her finger when she hit her. She said, we're not wrong.
I didn't do anything to her finger. I'm not a lefty. I don't have it.
Do you want to set it for trial?
I mean, we'll go to, if she wants me, like, we'll go to trial. Okay.
Judge, we thought we had a resolution between court costs. Mr. Morford's client doesn't want to pay the court costs. My client wanted with a broken finger. She's got medical bills she's paying, so.
I'm fine with court costs.
Okay. Roger, she would take it.
Okay, then we're okay if the 90-day one cost would be on,
Ms. Bryan? Yeah, everybody's agreeable with that?
sounds like my client certainly is.
Yes.
Mr. Bryan is, Your Honor.
We have a resolution if we'll approve it. We'll do that.
Okay. So that's January will be the 90-day period. So let's go to January 19th.
Check real quick, Judge, but I can't imagine that far out of being an issue. That's Martin Luther King Day, the 20th, according to my friend it is. We'll be here Tuesday.
Let's go to the 26th.
That's good.
Judge, do you mind maybe going into early February? I'm supposed to have my knee replaced on the 6th.
Okay.
And I don't want to push the return to work, but I will return as soon as possible.
February 9th.
I'm available, Judge, yes, sir. Put it down, just.
Be dismissed if there's no further problems and the court costs are paid on this Barnes case.
Thank you, Judge.
You're welcome.
But you got to come back that day.
And we'll have time when we're.
Both parties ready to
Okay.
Bring them back to the
So I pay it when I come back.
Which party's going to pay the costs?
Brian.
State of Ohio versus Jason Moore, case number CRB 25591, CRB 25570.
Jaden Moore is Mr. Morford's case, and Jaden Moore is at Bellefonte inpatient now. If you recall, he's the first one that went there. Looks like we're going to have several.
Is that the dealings with Ms. Arvin, Your Honor?
It is. So, as far as I know, he's still an inpatient there. So I will message her after court today to try to get an update, but I would suggest just continue this to another date to see where he is.
Please.
I did see, she didn't say his name, but she has put out a feeler for a 19-year-old with THC issues that's homeless and needs care. So I don't know if anyone responded to that, but it was on our text chain with the court. She's looking, I assume, looking for placement for him. Okay, let's put it on the docket for next. Are you available on Monday, the 20th?
I believe so, Judge.
Okay. October 20th for pre-trial for Mr. Moore.
Thank you, Your Honor.
You're welcome. State of Ohio District Benches Reading. Case number CRA 25632, CRB 25633, and TRC 252545, A, B, and C.
They're going to take their case to the grand jury. Okay. What I'm going to suggest to anybody should do is waive it for a minute here so that you can keep the bond that you have. Okay. They'll take the case. This is Jason Green. They decide to indict you. Summons will be sent to you either. That will be knocking on your door or certified mail. And then like start all over, Mr. Reed and Ironton. And the reason you're not staying here is because I'm Catholic. This is being waived. The reason to keep it here.
Okay, where are we on that? I've got the report, thank you. And it looks like some good signs, so there's a lot going on with Mr. Reed. But it appears to me you're the best possible place you could be to get help and get through this.
Judge, the state, is my understanding, intends to take this case to the grand jury, so we waive on the felony.
Okay. So the OVI is going to be nollie to the grand jury?
Yes, Your Honor.
All right, and I don't have, let's see, was it, I don't have that file, 25632 did not make its way out here. Is that the aggravated possession charge?
Yes.
Okay. No, I guess it's noted on, okay, I'm sorry, I misspoke. It's on the outside of the file, let me see if it is in the file. He has a bond up,
Yes, Your Honor.
so he's gonna waive.
Yes, Judge.
Okay, I do have the charge in the file. Okay, so the felonies are waived to the grand jury, which is 25,632. The misdemeanors are all nollie to the grand jury.
Looks like
So, Mr. Reed, what your lawyers tell in court, you have a right to a probable cause hearing in this court. It's not the trial. But felonies are considered so serious that a judicial officer has to look at the evidence and say, yeah, there's enough reason for this to go to the grand jury for an indictment. And he's waiving that for you and saying your case is going to go to the grand jury. And that's what you're agreeing to when you sign the document they put in front of you. Is that what you want to do? Is that what you want to do?
Say sir, well, yes, sir.
Okay. All right. He has signed the waiver.
I need something like that, please.
So your case is going to go on down to the main courthouse in Edenbridge. Your case is going to go to the main courthouse because it's going to get presented to the grand jury. You hear a lot of stuff in the news about indictments. That's what that is. When you're, again, felony so serious, the prosecutor has to meet with people from the community in secret. That's what a grand jury is. Present evidence, and they say, yeah, you got enough evidence to take this person to trial on this case. That's going to happen to you because your case is going to go to the grand jury. And then it'll be, the misdemeanor OVI is going to go with it down to the common police court. Here's the thing, and I think Mr. Morford will concur with this. From reading your report and from my knowledge of the court system and having been a prosecutor, defense lawyer, I know all the seats in the courtroom. The best thing you can possibly do is do what you're doing right now. Is get treated, go into that court with a good treatment record, because they got people that they can send away that aren't doing what you're doing. And here's the other thing I see. You've got a bunch of medical issues and stuff. Where you are, they're going to help you deal with that. If you go back out, if you leave and go out on the street, you're in a lot of danger, because the people out on the street aren't going to help you get medical treatment. And it looks like you really need it. You got some serious stuff going on. So stay where you are, get really good reports, when so far you're headed that way, and take that up to the next level, present it, and that's going to get you the best outcome on your cases that you've got at the common police court.
I would absolutely agree with that.
So, stay in treatment. Your cases are going on to common police.
Thank you, Your Honor.
Thank you.
Good luck.
State of Ohio versus Daniel Harless, case number CRB 25652. Set for arraignment, Your Honor. Daniel Harless.
Daniel Horowitz. Yes, sir.
All right, sir, are you Daniel Harless?
Yes, Your Honor.
Mr. Harless, it's alleged that at Windsor Township, October the 11th of this year, you knowingly caused or tried to cause physical harm to Corey Justice. So the charge against you is assault. It's a first-degree misdemeanor. Maximum penalty is 6 months in jail, $1,000 fine. Do you understand the charge?
Yes, Your Honor.
And you do understand the rights you have as a defendant?
Yes, Your Honor.
How do you plead to this charge?
Not guilty, Your Honor.
Do you want to be considered for a court-appointed lawyer?
Yes, Your Honor.
Do you have a job?
Yes, Your Honor.
What do you do?
Work facilities for Marshall University.
Okay. Are you paid by the hour? How do you get paid?
Paid by the hour.
How much per hour?
It's $12.89. It's $23,800 a year.
Okay. Do you have any dependents?
Yes, Your Honor.
Tell me about that.
I have my wife, my 2 juvenile children, and my of-age son that's homeless that lives at home.
Okay. Well, you're qualified then with the dependents that you have. So I'll appoint Mr. Smith, Roger Smith, will be your attorney, entering a not guilty plea for you. He did post a bond and he has been fingerprinted, so bonds continued as posted. Is there any kind of protection order requested?
Yes, Your Honor.
All right, Mr. Harless, is it any problem for you to stay away from Corey Justice?
No, Your Honor, he vacated.
Y'all don't live together? or
No,
anything like that?
no.
Okay, I'm entering what's called a protection order. It's just to make sure nothing else is alleged to happen while the case is pending. You stay away from him, don't go around him, don't contact him, don't text him, don't post anything about him. Just let everything die down. All right, so Mr. Smith, I am setting pretrials in November. Any date but the 7th is already pretty busy, so.
I could do the 10th, 14th, 17th, any of those.
I'm sorry, the 10th?
The 10th of November, 14th or 17th.
Let's do the 14th. but
Yes,
The
sir.
10th's getting kind of busy too.
I'll do 14th.
November 14th will be the next hearing, pretrial at 10 o'clock.
State of Ohio versus Madison Atkins, case number CRB 25651.
You Madison Atkins?
Yes, sir.
Ma'am, you're Madison Atkins.
Yes, sir.
Ms. Atkins, it's alleged that at Fayette Township on October the 11th, you purposely tried to defraud Walmart property without their consent. It's a theft charge, maximum penalty, 6 months in jail, $1,000. Do you understand this charge?
Yes, sir.
Do you understand the rights you have?
Yes, sir.
How do you plead to this charge?
I plead guilty. What I did was unexcusable, and I should have never done that. And I never want to put my future in that ever again. I never want to jeopardize that ever again.
Okay. I'll accept your guilty plea. You understand that means you're admitting the charge is true.
Yes, what I did was unexcusable, and there's no nothing about that.
Okay, so my usual procedure, which I'm going to follow, because I've been surprised sometimes. I have a pretty good eye after doing this for a few years of who's going to test positive. And I've been wrong before when I say, I don't think this person's going to test positive, and they do. Anybody on the shoplifting, I make them do a urine screen.
Okay.
Because 80% of the people that shoplift are dirty. So then it becomes a treatment case. So we got to fix the problem. That's an issue. So go to the probation office. That's when you leave the courtroom, go out in the lobby, 90-degree left turn, west side. They'll direct you where to go to get your urine screen. When I get the results, we'll come back and then we'll decide what the sentence should be. So go
right.
do a urine screen.
Okay, thank you.
State of Ohio versus Taylor Burnett, case number CRB 25650.
All right, and ma'am, you're Taylor Burnett.
Yes, Your Honor.
I've been served a copy of the complaint. It also alleges October 11th, 2025, Fayette Township, we purposely tried to defraud Walmart property without their consent. Theft offense, maximum penalty, 6 months in jail, $1,000 fine. Do you understand the charge?
Yes, Your Honor.
How do you wish to plead to this?
I plead guilty. It was very unexcusable, and it was a lapse in judgment, and I would never put my future at risk again.
Okay, same thing that I said to the previous, and I think you were together, I believe, from our.
Yes, Your Honor.
So go do a urine screen, come back, and then we'll do sentencing after we get your urine results. So
Thank you.
go to the probation office and get a urine screen.
State of Ohio versus John Marker, case number CRB 23115. PRC 23194, A, B, and C.
Mr. Smith's case, pretrial.
Yeah, I have missed a bunch of the treatment stuff. I gotta work on it. I gotta get that fixed.
Yeah, Judge, excuse me, I spoke with Mr. Heald. It's my understanding that in return for a guilty plea to the OVI, the state would dismiss endangering children and the domestic violence cases. And we would delay sentencing, I guess, because he's in treatment, see how that goes. And he has had some issues with treatment.
I'm gonna
You
get
got a
that.
report and file date today. Have you seen
Oh,
it?
I have not, Judge, no.
I'm gonna get that fixed.
He says he's going to fix that.
I had to get my schedule fixed at work and everything, and it's been, I got 4 kids, I gotta get them all situated in daycare, and but I do have scheduling fixed with work and everything. I can start everything, getting it all taken care of now.
Sounds like you're on the right track.
Yeah, no, I got the assessment done and everything. I didn't start the groups or anything like that yet.
Taylor was here.
I missed a bunch of the groups and then all that stuff. That's all it is. But I will be taking care of it after all this.
Okay, so what pleas do you wish to enter?
Judge, he would enter guilty plea to the OVI, and I've explained to him, the carrot is you get on track like you say you're going to. The state says that would count for the dip score. If he doesn't, you've got 180 days, you can put him in jail. So I'm hoping he understands the seriousness of getting on board with Bethesda. He says he does. But it would be guilty plea to the OVI and dismiss the other 2.
Is that correct, Mr. Barker?
Yes, sir.
Okay, I want to read the report of the investigating officer into the record here. I think it's important. February 20th, 2023, so this is an older case.
It is.
Which I definitely wasn't on.
Yeah, he was out of pocket from April 23 until this past summer. He had a warrant outstanding. I was on stationary patrol, US 52, near milepost 21, observing westbound traffic when I observed and heard a vehicle traveling eastbound. The vehicle was traveling eastbound in the left lane. The vehicle's exhaust was abnormally loud and unusual. There were no other vehicles in the proximity of the vehicle. I pulled out of the crossover, caught up to the vehicle on US 52 near milepost 22, initiated a traffic stop by activating overhead lights, made a passenger side approach, asked the driver, John Barker, for his driver's license, proof of insurance, and registration. He was able to provide me with all this information. Front seat passenger was identified as Rebecca Littlejohn. There was a juvenile child in the back seat. This is at 1:30 in the morning.
I was taking him home.
While speaking with them, I noticed a strong odor of burnt marijuana emitting from the vehicle. While speaking with Mr. Barker, I noticed his eyes were bloodshot and glassy. His pupils were dilated. His speech was thick. I explained the reason for the traffic stop. He stated someone had stolen his catalytic converter from the vehicle. I transitioned to the driver's side of the vehicle. I asked Mr. Barker to exit the vehicle and standing in front of my patrol car. I asked him if he had a medical marijuana card, and he stated he did not. I told him that I could smell burnt marijuana coming from the vehicle, and he stated that he and Miss Littlejohn smoked marijuana, but stated he had not smoked prior to the traffic stop. Pat down for weapons was conducted. He was secured in the backseat of the patrol car. Approached the vehicle on the passenger side and asked Miss Littlejohn to exit the vehicle and stand in front of the patrol car. As she exited, I asked her how much marijuana she had smoked. She admitted to smoking prior to the traffic stop. She also admitted and voluntarily surrendered a bag containing marijuana from her person. Stated she did not have a medical marijuana card. Probable cause for her person was searched was conducted. I asked if she could remove the child from the vehicle, and she complied. She was also secured in the backseat of the patrol car. Asked Mr. Barker to exit my patrol car and conducted standard field sobriety tests, administered horizontal gaze and nystagmus test. There was lack of smooth pursuit, distinct and sustained nystagmus at maximum deviation. Administered the vertical gaze nystagmus test, did not observe a nystagmus. I administered the lack of convergence test. Both his left and right eyes began to converge, and the hook outwards, there was a lack of convergence present. I examined his eyes. His pupils were abnormally dilated. They had normal reaction to light. He performed walk and turn tests. I observed 5 clues for impairment. He stepped off the line, failed to touch heel to toe, raised his arms greater than 6 inches, made an incorrect turn, took an incorrect number of steps. Also observed him to have leg tremors. He performed 1 leg stand test, and there were 2 clues for impairment. Swayed side to side, raised his arms greater than 6 inches for balance. During the test, also observed leg and eyelid tremors. Asked him to open his mouth. I noticed his mouth was dry. He had heat bumps on the back of his tongue. I placed him under arrest for operating the vehicle under the influence, handcuffed him, advised him of his Miranda rights. He was served with a copy of the charges, released to Trooper White to wait for a ride. He consented to a urine test. So do we have that?
We do. I gave you a copy of that. Is that the one that I gave you? We did. I didn't change the copy yet. Approach your.
Yes. So he was also positive for methamphetamine and amphetamine. Just for the file, or you want?
Well, that's our only copy.
Yes,
so
okay. I was going to copy it, I just didn't have a chance yet. I'll make one for the court as well.
What's being recommended?
Your Honor, well, of course, we hadn't gotten a report from Bethesda yet today, but we wanted him to be.
Well, he's non-compliant.
Well, I know. We want compliance, I guess, would be our chief thing. It's a first offense. Meth is concerning. It's 2 years ago, but obviously, there still is a need here. So we wanted to follow through with the treatment. Otherwise, it's a first offense. So, and we realize that there are other issues involved with not having come forth for a couple of years. I don't know what the delay was. There's also this domestic violence charge from 2023, and we've made efforts at locating the alleged victim. So we acknowledge that one.
She's outside.
Oh, is she here? Okay, well, I guess we want to hear, make sure she is.
What's her name?
Elizabeth
Goodall.
Is she in the courtroom, or?
She's outside with the kids.
Elizabeth Goodall?
She wrote a statement to drop the charges shortly after it happened. Nothing actually happened. There was no domestic violence. I would never put my hands on them.
And can you come out and talk to the prosecutor?
Are you and Mr. Barker still together?
Sort of, yeah.
Okay. Well, we have a domestic violence charge. It's 2 years old. Take these very seriously.
And then I put in the other charges dropped and all the other dismissed.
Do you have any problems with them since then? Well, that's this. Okay. So, Your Honor, on this domestic violence charge, Ms. Goodall is here, and she tells us that she gave, and I don't have that specific, I don't know if that file's here, but anyway, she says that she asked for the case to be dismissed a couple of years ago. Of course, that doesn't automatically cause us to dismiss a case. However, she tells us that she doesn't want to proceed, and there have not been any further problems between them. I think that you have children with them?
Yeah.
They have children together, so
One on the
probably
way.
the same children.
Yeah, we have 2, and then we have another one more.
They have another one on the way.
I'm sorry, what is her name?
Elizabeth Goodall, she's the alleged victim on the domestic violence charge.
All right.
This is from 23.
So
You're not, were you ever known by Little John?
No.
Okay. That's the lady that was with him when he got there.
That's my mom's family.
That's weird.
What's the case number on the domestic? Because I don't think I have it.
Okay, I think it might have already been known.
And I dismissed the TPO, but just.
Yeah, we dismissed the TPO back then, and our notes indicate it was Nolly, but I also
With the right to refund.
think it might have still been on the docket today, and I could be mistaken about the whole thing. It might have been resolved a long time ago.
Yeah, that's here, I've got it.
July.
That's it.
All right.
Okay. All right, so apparently it was resolved. It's not showing on the computer. Okay, Mr. Barker.
Yes, sir.
Do you have any statement or explanation you want to make? And particularly the thing that I'm interested in is why you were gone for 2 years.
That was, I started going up to Maryland to start with the custody with my other son. I started working. I really honestly forgot about having the warrant, if you want me to be completely honest. I know that's not very believable, but we went over this the last court date, and I am very, and I definitely didn't want to go to jail, so I definitely would have rather had came to court than went to jail. I know I don't want to have a warrant. I'm not going to be just bouncing out on court, and I've showed up every day since then, other than once, but I was in the hospital. The non-compliance with the Bethesda is really just, it was scheduling issues with work and childcare. I've got work figured out now. As of this week, they just put out the new schedule. I'm able to make it to groups. I'm able to make it to everything now without interfering with work. So,
Where do you work?
Applebee's in Ashland.
Anything else you want to tell me?
No, sir.
All right, I'll allow the state to dismiss the endangering children, but I'm going to consider it in the sentencing. I think it needs to be considered. He had a juvenile with him at 1:30 in the morning while he's under the influence, admittedly, and then doesn't appear for 2 years on this case. So you got to get some jail time. Otherwise, if I'm sitting out there watching this or on YouTube watching it, I'm thinking, you know what, I'm just not gonna show up, and I'll take my chances. And then when they finally nab me, then I'll just get what I would have got 2 years ago. Why not? There's gotta be a price to be paid for thumbing your nose at the court and taking off for a couple of years. So, on the OVI, I'll impose a $500 fine. Order you to pay the court costs. There'll be a 6-month license suspension. The issue is whether it was started at the time of the citation or starts now, so let me look and see.
Well, it was a year-end test, so I don't know.
Yeah, so it starts now.
It was year.
There was not an automatic license suspension, so the 6-month license suspension starts today.
He would ask for work permits, Judge, to get to Applebee's to work in childcare.
They have to have proof of insurance.
You have insurance on your car.
I mean, she has insurance on her car. My car is not running at the moment.
20 days in jail, and I'll suspend 15. I'm going to make it 60 hours of community service. I'm going to double the community service from what you would have got if you would have come in well, almost 3 years ago, 2.5 years ago now. 2 years of level 4 probation. I may suspend the dip school if he, so far he's done nothing. Here's what the report from Bethesda says. He was going to go get an assessment, which he did. John Barker has not remained compliant with treatment expectations at Bethesda. He presented for an assessment September 15th. His instant drug screen was positive for methamphetamine, amphetamine, and cannabis.
No.
Sir,
I'm sorry?
In the jail right now.
I'm sorry?
All up to 10 days in jail. He just went from 5 to 10 days in jail. I apologize. Too late. I'll set a hearing for him November the 14th, 1 month out. So it went from 20 days, 10 days suspended. November 14th for his review. That guy has done nothing that he's supposed to do. Nothing. And he's walking in here wanting to bark out orders and act like he's in charge. No.
We had a DUS on that as well.
Okay, give him another 30 hours of community service.
Your Honor, we're ready to go to the Lawrence County Jail. State of Ohio versus Ricky May, at the Lawrence County Jail, case number CRB 25185A and B. And Angela Ray is on deck.
Okay. All right, you're Ricky May. Can you hear me, Mr. May?
Yes, sir.
Okay. He has a probation violation complaint filed, and I think, I was told there was going to be new charges also.
Well, there's a charge that's already been filed, and it is a telecommunications harassment, and it is set already for...
Oh, it's already pending then. He's been arraigned on it.
I believe
He was arraigned Friday on Your Honor.
Okay.
November the 3rd maybe is when it's set.
All right, so Mr. May, you have a right to remain silent. You don't have to say anything. If you do make statements, it's on the record. It can be used against you. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, and to make the state of Ohio prove any charge, including a violation of your probation beyond a reasonable doubt. Do you understand those things?
Yes, sir.
Okay, you've got a probation violation charge filed against you alleging that you did not report for probation July 14, 2025 as previously ordered, and that you got a new charge which was filed September the 10th of telecommunication harassment, which would be a violation of your prior probation.
Your Honor, there's additional.
Okay.
I filed that on Friday, and after court, deputies went out to his house and found him in violation of his probation. He was around the mother of his children, and there is a no contact order, Your Honor.
Okay. So that's an additional cause for probation violation. Do you understand the charge?
Yes, sir.
Okay, how do you plead to it?
Not guilty.
Now, I think you told me previously that Mr. DeLauder was going to be your lawyer. Is that still correct?
To my knowledge, yes, sir.
Do you want to be considered for a court-appointed lawyer? Do you have the ability to hire a lawyer now that you're incarcerated?
I don't think I'll qualify.
Financially?
Correct.
What's the state's position on bond for Mr. May?
Mr. May is piling up some discredit as far as the prosecutor's office is concerned. We believe that a $25,000 cash surety bond is appropriate. This is getting real serious. Now, this is Haley Corwin here. She's the young lady who begged us to make sure we got a no contact order, protection order, and all that previously, and then they were together. And there's also concern from the family of Mr. May about the children that these two share. And we have learned a little bit today, but there's some real worry about their well-being.
Where are the children now?
The children are, let's see, the stepmother of Mr. May is here, and his father are here. They could fill us in maybe if the court wants to.
Do they have, you have custody of the children?
Yeah. Yes, sir.
Where are they?
It's our understanding they're at the home, I believe, maybe with their grandmother. Yes.
Okay.
They're at home safe.
That's your mother's?
No, it's not my mother that's watching them, but they're safe. They're with a relative at home. They're with their other grandmother.
And that's in this state or another state?
This.
Okay. Is Children's Services involved? Or?
Yes, and I had contacted Children's Services earlier today, and I asked them to contact me back, and haven't heard anything back yet, but they're aware of the situation already.
Okay. So now this is the paternal grandparents' family, is that right? Okay. Do you believe the children are safe? I mean, that's going to be my primary concern right now.
Can I?
Yeah, that's what I'm asking.
I'm Rick's dad, and I do not think my grandbabies are safe.
Well, as of right, I know he's in jail, but as of right now, this minute, are they safe? Are they in a safe place?
No, they're with my ex-wife, and she has some issues she's battling with. Those children are living in filthy conditions that I wouldn't raise chickens in.
Okay, well then what I want to do, let's get Children's Services involved and get a response from them. So we'll wait till, let's make them know that this is urgent, we need a response, and I'll recall this later in the docket to decide. As of now, though, I'm going to set a $25,000 cash surety bond for Mr. May, and I'll revisit that later, especially after I find out more about the condition of these children. What's their ages?
2.5 and 4.
Oh, preschool. Okay, we got really young kids involved. So let's get Children's Services involved and get them. Do we have an address where the children are located?
Yes, sir.
Yes. Let's pass that on to Children's Services.
They have it.
Okay. All right. I'll recall this later in the docket. Thank you.
State of Ohio versus Angela Ray. case number CRA 25649, and Jacob Richter is on deck.
Ma'am, are you Angela Ray?
Yes, I am.
Ms. Ray, I'm Judge Capper. This is your arraignment hearing, and it's being conducted by teleconference. So everything you say is being recorded. Everything I say is being recorded too. If you admit something about your case that could be used against you, you have a right to have an attorney, to have one appointed if you can't afford one, to have bail, and to make the state of Ohio prove the charge against you beyond a reasonable doubt. Do you understand those things?
Yes, I do.
Your charge is possession of cocaine. It's a felony of the 5th degree. It alleges that on October the 13th, in Fayette Township, you knowingly were in possession of a controlled substance, that substance being cocaine. Maximum penalty for that is a year in jail, $2,500 fine. Do you understand the charge?
Yes.
Do you have the money to hire a lawyer?
Yes, I do.
You do have the money to hire a lawyer?
No, I'm sorry.
Okay. You don't have the money to hire a lawyer.
No,
You have a job.
I'm disabled.
All right, Mr. Smith, I'll appoint you to represent Angela Ray. What's the state's position on bond? And Ms. Ray, I'm showing an address for you in Ironton.
Yes, sir.
That's your home address?
Yes, sir, that's where I live.
Do you have a medical card?
Yes, sir, I do.
Ohio medical card?
Yes, sir.
Okay. What's the state's position?
Your Honor, if Ms. Ray would be agreeable to being assessed for treatment, we would not oppose an OR bond if she were to enter into whatever treatment is suggested that she should do. Otherwise, we would ask for a $25,000 cash assurance bond.
Did you hear what the prosecutor said, ma'am?
Yes, sir, I did.
Are you agreeable to seeking treatment?
Yes, I am.
Have you had treatment before?
No, I have not.
Okay. Focus is going to call and talk to you. Is the name of the organization that does treatment. And I'm going to assume you're going to qualify. And so what's going to happen is I'm going to release you to go to treatment with them. And then you'll come back before me periodically. If you do well, your case could actually get dismissed. That's as good an outcome as you can get. Your case gets dismissed after you demonstrate you're going to get clean and stay clean. If you don't want to do that, your case will go, because it's a felony charge, it'll go on to the grand jury, you'll leave this court and go to the common police court, and you can go to prison on a felony. That's what makes it a felony. Felonies can go to prison as a part of their sentence. You don't want that. You want to get clean and get the felony off your record, right?
Yes, sir.
Okay, so you got to do what is set up for you for treatment.
Yes, sir.
So I'll release her on a $2,000 OR bond to Focus. If there's some problem with that, then they'll let me know, and then we'll come back.
Judge, I'm here the 14th. I could do the 7th or 10th, but you said they're getting pretty full.
Well, but for something like this, I think we got to. So
Okay.
The 7th.
I can do the 7th, yes, sir.
November 7th will be your next hearing. 10 o'clock. You're going to get a call here shortly from Focus to do an assessment. I'll release you to their custody. If there's a problem and they won't take you, they'll come back and let me know, and then we'll go try a different route.
Okay.
You understand what you need to do?
I understand, sir.
Okay. Come back with a good report. You got to do what they tell you to do, unless it's illegal or immoral. Okay, that's all.
State of Ohio versus Jacob Richter, case number CRA 25648.
Sir, you, Jacob Richter, we need, the camera needs to be refocused. It's out of focus. Yeah, we're supposed to be It's still pretty focused. A little. It's focused more on your hand. The hand looked pretty good, but his face doesn't.
I'm sorry, sir?
Okay, I guess we'll live with it, but it's not the best. Anyway, all right, Mr. Richter. I'm Judge Capper. Okay, there we go. Now you look great. We can really see it. I'm Judge Capper. This is your arraignment. You've got a charge out of Pickaway County, Ohio. So I'm arraigning you on that.
Yes, sir.
You have a right to remain silent. You don't have to say anything. If you do make statements, it's on the record. It can be used against you if you admit something. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, to make the state prove this charge beyond a reasonable doubt. Do you understand those things?
Yes, sir.
Okay, I've got a warrant. Actually, it says attachment for contempt from the Pickaway County Court of Common Pleas, Juvenile Division. And it's alleging that you failed to comply with a court order there, and they want you to serve 21 days in jail for failure to comply. So you have a right to a hearing here to decide, are you the Jacob D. Richter that Pickaway County wants, and is there good reason to send you up to that court to face this contempt charge? You can have a lawyer, you can have one appointed if you want to have a hearing here. I won't be deciding whether you did or didn't commit the contempt. I'll be deciding if you're the person and if I should order you to go to Pickaway County.
Yes, sir.
Okay, so do you understand that?
Yes, sir.
Do you want to have such a hearing, or do you want to agree you are the person and go up there and take care of it?
I'm the person, sir.
Okay, so you're going to waive a Rule 4 hearing. I'll let you post a bond if you...
May I say something, sir, like before you send that?
Yeah. It's on the record, remember?
Yes, sir. My mother was in the hospital right before this 21 days was sentenced to me, and I don't know, I lost contact with her before I was supposed to do this time, and I don't know if she's still in the hospital, I don't know if she's alive, if she's passed away, I don't know anything. And that's really got to me. But I can post, I have $113, and I can post it right now. It's in my person. I just want to make sure that my mom is okay. I just want to be able to have contact with her. That's all I care about.
Well, I don't think that's enough of a bond to secure your appearance to go up to Pickaway County. So I would set bond at $5,000, cash or surety. Do you think you could post such a bond?
No, sir, I don't have anybody but her, and that's even if she hasn't passed away yet. I don't know that.
All right.
I can turn myself in. I just need 72 hours. That's all I'm asking, sir. I have $113 cash.
Well, I'm not going to give you that. You got to go.
Okay.
You can argue that to the judge in Pickaway County. That'll be up to them. But you apparently didn't do what they wanted you to do, so I'm going to make you go up there and face the music.
Yes, sir.
I've had a lot of mothers and grandmothers die on court days in this court, so I'm a little bit cynical.
Yes, sir.
About that. So
how long do they have to come get it in or whatever?
Well, I haven't decided that yet.
Okay.
So you can't post any bond?
No, I just have that cash. I don't have any co-sign. That's all the money I have.
I'm going to give him a week.
7 more days?
Yeah, what actually, it'll be, I'll set it for be 6 days, because today's Tuesday. I'll give them till next Monday.
Did you say it was to serve 21 days, is that correct, sir?
That's what their warrant says, 21 days in jail.
Okay. Now, does this time count, since I'm sitting here on that warrant?
I don't know, that's up to the judge in Pickaway County.
Okay.
So what I'm going to do, I'll put Mr. Richter back on my docket for the 20th at 10 a.m. I give Pickaway County until 8 a.m. on the 20th to pick him up. So if you're still sitting in our jail, next Monday at 10 o'clock, I'll see you on a teleconference and we'll decide what we're going to do then.
Yes, sir.
Hopefully you'll already be gone, that they have
Yes,
come and
sir.
got you by then. We'll send this down for signature. So if the jailer's listening in, go ahead and let Pickaway County know they can start heading south.
Yes, sir.
To pick up Mr. Richter. Any questions, sir?
No, sir.
Okay, that's all.
We have a recall, but we're not ready for it yet.
Okay.
State of Ohio recalls Madison Atkins, case number CRB 25651.
Okay, I'm not going to require you to get treatment with the screen results that you got. Is there anything you want to tell me before I sentence you?
On the paperwork, there is two things. On the paperwork, mine and Taylor Burnett's birthdays are mixed up on the paperwork.
Okay.
Mine's 08/05/2005. Hers is January 6, 2005. Sorry.
Yours is 08 what?
08/05/2005.
Okay. We can get that, has to be changed out. You can do it.
I don't think we can change that from the screen.
Yeah, you have to log in out front. You make a note of that, do that.
I'll let the clerk take care of that. Anything else you want to tell me then?
Well, I guess whatever after the sentencing is, if there's any programs or anything that I can do, or whatever fines or anything like that, community service volunteering, I don't care to do it, because I would like to hopefully get this taken off of my record so I can continue to go to school. And
Where are you going to school?
I go to Mount West Technical and Community College, but I graduate in December, and my goal is to go to LPN school.
Okay. Well, this is an offense that can be expunged at some point,
Okay.
but you have to be off of probation, I believe, a year. You have to
Okay.
check on that.
Okay.
So, it is a mistake.
Yes, sir.
It is, you know,
It is what it is. I have to deal with it, but I accept
you know,
the consequence.
honesty is a really important thing, and when if you are going to work in the medical field,
That is one of the number one things that you have
you
to
gotta
have,
be
yes, sir.
licensed. I mean, people work around drugs and that sort of thing, and if
Mm-hmm.
someone will steal, maybe they'll steal drugs too. So that's got to be a real concern for people that might hire you.
Right, for sure.
So, all right, on the theft offense, I'll impose a $100 fine, or you pay court costs. 10 days in jail, which I'll suspend on the condition you do 5 days of community service.
Okay.
You're ordered to stay out of Walmart,
Mhm.
all
Yes, sir.
Walmarts.
Yes, sir.
2 years of level 5 probation, which means non-reporting except for a review hearing, which is going to be on April the 20th of next year. So they give you've got 6 months to get everything done. If you do, you don't have to come to the hearing. So here's how you could go to jail on this. I don't want you to go to jail. but believe it or
Neither do
not-
I, sir. I never want to go
Okay,
back
you don't need
there.
to say anything. I'm talking now, so you just need to listen.
Okay.
The way you can go to jail is blow this off, and I have people do that. They just walk out, don't think about it again, and blow it off, and don't do anything they're ordered to do. You'll get a warrant eventually on April 20th of next year. If you do that, then you'll wind up getting arrested on the warrant and going to jail. So just take care of it, do what you're supposed to do, and go on and have a good life, eventually get it expunged. And just remember, your reputation for honesty and truthfulness is one of the most important assets that you have.
Yes, sir.
So don't manage it lightly. Go see Mr. Major in the probation office. That's to the left where you went to get the screening before.
Okay.
9 a.m. on April 20th, your review.
State of Ohio versus Christopher Brammer, case number TRC 25721, A and B.
It's Mr. Smith's case, please write.
Your Honor, this is a case where my client did have an assessment. They did not believe he needed treatment, so in speaking with the prosecutor, it's our intention to enter a no contest plea with stipulation of facts sufficient for a finding of guilt had we proceeded to trial.
I'm sorry, repeat that.
I'm sorry, with the no contest plea, Judge, with facts sufficient for a finding of guilt had we gone to trial. He's going to have to do 3 days in jail because it's a high score. We were hoping he could do treatment and get that knocked down, but that's not the case. He would ask to be given a reporting day so he can make arrangements of work to do that 3 days.
Yeah, it's
It's not even close, yes, and we were hoping
21 test.
treatment, he just didn't get in.
Mr. Hill.
Well, it is a high score, Your Honor, and we did have discussions about the fact that if he were to go through treatment, then we would be able to take maybe a different look at the amount of jail time that might be required, but apparently it was determined that he didn't need treatment, and the mandatory minimums would require at least 3 days in jail, so that's what we're going to recommend. We trust that the court will find him appropriately given the test score. And we're going to ask for a 6-month driver's license suspension going back to the date of the offense and whatever other sanctions that the court chooses.
All right, Mr. Brammer, anything you wish to say?
No, sir.
The box on the citation for proof of insurance was not checked. Do you have proof of insurance?
Yes, it would just take me a moment to locate it online.
Okay. You probably should, he's going to need, if he wants driving privilege, which I assume he does, he's going to have to show that to Mr. Major.
Yes, Judge.
Was that a no contest?
No contest, finding him guilty. Okay, for jail, I'll have you report to the court on Monday or Friday. What's better for you?
Friday would be better.
Yeah, preferred Friday to come in?
Possibly sometime in November. I'm working a lot of overtime until the end of October. I work for a contractor through American Water, and we have a lot of leaks we have to fix by the end of October.
Okay, November 7th then?
That would be good.
For Friday. Okay, based on the test score is really high, my rule is I kind of have a sliding scale. The higher you test, the higher I make the fine. So you're going to get a $1,000 fine. Or to pay the court costs. 180-day license suspension starting today. Well, I'm sorry, no,
It was
started
up,
the day of the offense.
I think it's up yesterday, if my math is right, April 13th.
The 10th.
Okay, 10th, okay, so we probably don't even need it for a majority hearing statement.
Just go to the DMV. Your Honor, if I may ask, what was the time of that November 7th court date? I'm sorry, I didn't get to write that.
11 a.m.
Yes, sir. 11.
Be here by 11 a.m. on November 7th. Uh, 20 days in jail, 17 suspended. He's to report from jail November 7th at 11 a.m. 30 hours community service. He has to go to the driver intervention program also. His review hearing will be April 20th of next year at 9 a.m. He can have a permit for work, community service, come to court, to go to the dip school. Anything else that needs driving purposes?
No, sir.
You'll get that from Mr. Major, the probation officer. You'll get your permit, and you'll need to show him the proof of insurance. Was there other charges? There is a B case. Lane violation, $10 fine. Okay, see Mr. Major in probation, then you're free to go.
Yes, sir.
Staff comments out.
Take care, Chris.
State of Ohio versus John Guido, case number PRC 25944.
Mayor, approach your honor.
Yes. Okay. Is this my copy there?
I can have him print me another one.
May we approach your honor?
Yeah.
You sound like me. That's what we got.
I've never been incarcerated ever. This is the first and second time. This is my first offense. I mean, it's not free.
Okay. Sure. I spoke with my client, Judge. He will, at this point, enter a no contest plea stipulation of facts sufficient for finding him guilty on both the hit skip and the OVI. If we
Is that
can.
correct, Mr. Rio?
Yes, sir.
Okay, so what I'm going to do, I'm going to accept your guilty plea today. You just started counseling, you haven't been at it very long.
Yeah, only a month.
So I'm going to let you go ahead and get more of a history with them. Plus, there was other people involved in this incident, and I want a statement from them. So I'm going to let the prosecutor try to get a hold of them, see what their damages are. I'm told that you had insurance coverage.
Yes, I did. And I was told.
Which company was that?
Geico, and I was told that this claim's already been paid out.
Okay. Well,
I was told, I don't know.
I want to hear from them. I want to make sure they're taken care of, their damages are resolved. I'm going to set it for a hearing November 14th for sentencing. So continue with your counseling, get a good report then, and we'll see what the prosecutor comes up with from the other party that their vehicle was damaged. And I don't know, did they have injuries?
No.
Okay, November 14th, 10 o'clock, next year.
Thank you so much. I appreciate you.
Thank you, Your Honor.
You're welcome.
State of Ohio versus April Seelock, case number TRC 25-1892, A and B.
This is Mr. Smith's case for pre-trial.
It is just, we will provide the hearing test results this morning, so I'll need the brief continuance to go with my client and review those. But they are back now as of this morning.
You want to come back?
Judge, can we come back on the 14th date?
Yes. So November 14th will be the next hearing, and that's it to request the defendant.
State of Ohio versus Jessica Smith, case number TRC 25-2036 and TRD 25-1430. Jessica Smith.
It's Mr. Smith's case, for pre-trial.
Judge, she was in treatment. I can't remember who she was in treatment with. I don't know if she's inpatient and maybe.
She was with United Family Recovery.
What's her name? I can call Jessica.
Jessica Smith.
I'm assuming that's not her on TV.
No, that's Rainey.
Okay, oh, yes, on it, Rainey, yes.
State of Ohio versus Rainey Tawney, case number CRA 24-191, CRB 24-4.
This is Mr. Stratton's case. Anyone heard from Mr. Stratton today?
I have not, Judge.
Okay, it's my understanding Ms. Tawney is doing well and is getting recommended for the family program. Yes. Got a report from the counseling center. a good report. Anything you wish to say, Ms. Tony?
I just want to say that I'm grateful for you being able to hold me accountable, for being able to correct the mistakes that I was making when I wasn't realizing in my right mind what I was doing, for caring enough to put me in jail, but caring enough not to send me to prison, giving me another chance. I'm in a good place. I have a lot of good things going for me right now that I didn't have before, like these PRSS classes and this internship. We got a vehicle, so I'm just really grateful right now. I don't know how this whole family thing is gonna work out, because we're 12 on the list, and it makes things a little bit difficult for me and Drew because I'm not allowed at his place, he's not allowed at mine, and the baby's not allowed at his place either. So I'm not really sure what's going to happen there.
All right, well, let's just you gotta keep working at it. You've made a lot of progress since we had a issue in this, and obviously, we could have been well past this, but that's in the past. Now we're starting a new basis, so you gotta build from where you were, and you are.
Okay.
So you gotta stay positive, keep building. Don't think, well, I wish it was this way.
Okay.
You're in line to get in that program. You've been in the program before, and you know how it works. And I think it'd be a great option for you and Andrew. So let's stay the course.
Okay.
I'll see you in a month, November 14th. That's
Okay.
what I said his case. So
Thank you.
keep doing what you're doing. Stay
All right, I
positive.
will. I appreciate it.
Okay. You're welcome.
Thank you, Your Honor.
State of Ohio versus Nicholas Atkins, case number CRA 24294, CRB 24295, CRB 24293.
This is Mr. Smith's case.
You need the card? No, that's for him.
It's a good report for Mr. Atkins. So, where are we on these cases?
Your Honor, we have a possession of fentanyl charge. This goes back to 2024, back in, I guess, May or June. And we also had a couple of cases involving a victim, Natasha Pleasant. She came in some time ago and asked for the protection order to be dropped. Do we have anything close recently? Okay. Okay. And her indication was she just wanted to get treatment. So he graduated from OVP, right? And now he's at this place in West Virginia. So and I didn't read all the way to the bottom. I don't know if they're recommending anything at this point or.
They just say he's compliant, he's working, I think it's a sober living type facility where he pays something to stay there.
Yeah, I have 5 more months left to complete. I plan on completing there.
He has a full-time job, he pays them $125 a week. They do have some programming apparently that he takes place there and he participates in.
We wanted to continue with that. A good thing he's working. Where are you working?
It's called Cable Contracting. I'm getting ready to start a new job next week in Chesapeake for a guy named Bill Rader. He has a garage.
Okay. Well,
Mechanic work or?
Yeah, okay.
Maybe we come back in 2 months then rather than.
Be fine, Judge. I'll check my calendar.
Mid-December.
Would the 19th work, Judge, or yeah, the 19th, I got to travel the week before.
December 19th
Yes,
is
sir.
the next hearing
Okay.
for Mr. Atkins, 10 o'clock.
Thank you, Judge.
You're welcome.
State of Ohio recalls Jessica Smith, case number TRC 25-2036, TRD 25-1430.
Say there was nice enough to call, and it's not good news. She's ASA. She's left.
Well, they're both misdemeanors, so there'll be warrants issued for this court. Bench warrant for failure to appear.
Yes, sir.
And they can treat.
State of Ohio versus Devon Leonard, case number CRA 25195, TRC 25619, A and B, CRB 2543.
Mr. Smith's case. Is this Southern Hope? Is making steady progress. Do we have a time frame for him when he'll complete?
I'd say about another 4 months at least.
Okay. Are you working yet?
Yes.
Okay. We could do a couple months on him too. You want to do that same day?
December 19th, Judge. Yes, sir, that'll be fine.
December 19th, be the next hearing on all the cases.
State of Ohio versus Richard Sodine, case number CRA 24-591.
Mr. Smith's case, I had an issue with QRT on this one.
Yes, sir, mine's insured.
What? No.
Good.
So he's going to continue an inpatient.
He is, Judge. There was a referral to QRT, and Megan was here last time, said she would take him, but she's not here today.
Okay.
There was some confusion about that, and Megan wasn't, she reached out to me, but we never really did come to the conclusion of what exactly happened on that.
between now and next hearing, Judge, I'll reach out to her and confirm whether he's going to be qualified or wants to do that. I'll find out.
Okay.
Yeah, usually she's pretty good about that stuff. Maybe there was some reason presented that thing happening, but she wasn't sure. Yeah, we'll get you sorted out. I'll find out. Yeah. It's not a deal breaker. Ain't gonna put you in jail.
No, we're going to film it.
November 14th.
Yes, sir. It'll be fine.
Preliminary hearing.
I'll send an email to your case manager.
State of Ohio versus John Pennington, case number CRA 24664, CRD 241824, CRD 241610.
John Pennington.
He was Lawrence County Recovery.
He was at Lawrence County Recovery.
It's, I'm hoping he's not like the other lady. Hopefully he's still there. But he's not contacted the office, and I've not seen him today.
He was, in the end of August, he was at their sober living facility. And we reach out to Orange County Recovery.
Who is it?
John
Pennington.
Nice to have him.
Okay, we'll recall that.
State of Ohio versus Rusty Ratliff, case number CRA 25630. Your Honor, he has been picked up by Claremont County.
All right, this was a Rule 4 to Claremont County. He was picked up by Claremont County, so the case here is dismissed.
State of Ohio versus Jeremy Bachman, case number TRD 25376, A and B. Set for sentencing, Your Honor.
Mr. Smith's case set for sentencing. He's in an RRS.
You don't start with those.
Okay, looks like he failed to appear.
It was my insurance, what we talked about last time. Yeah, I thought we referred to somewhere else. OVP. It's a second insurance. No, because I didn't have insurance. I didn't, they didn't give you a referral with deputy. That's what I was thinking.
Case number is 25376.
Judge, we're trying to sort out his insurance. I've suggested he go to OVP. If we could come back by November 14th, I'd have to talk to Mr. Hill. He's okay with that. I'd rather see him get treatment than just do 10 days in jail and be done with it. I think given it's a second, and that, it's 7 years now, but it's still a second offense, I think that would be the
He has health insurance.
best route.
No, you're not.
Have a medical card.
Why couldn't RRS?
Let him explain.
Because the coverage, it was too much for me to afford.
You don't have a medical card?
Yeah, I don't have a medical card.
Okay, and you're working now?
Yes. And make too much for the medical card. Because I try to get all the.
You're gonna want that, you'll have to pay anywhere you go then.
Yeah.
You don't have a medical card, you don't have health insurance.
Some of them do a sliding scale, but I don't know who.
I got a sliding scale. I can give you the prices on ours. Yeah, okay, I have it. You have ours, all right.
But that's why I was trying to do the debt, because it was, you said, you got as crazy as OVP was.
I don't know what their price is. I couldn't tell you.
So you all haven't had that discussion yet? I mean, this is something you can still talk about as far as the sliding scale?
Yeah, I can help them out.
Yeah, 'cause
Yeah,
I do know their prices.
Okay, well, he'll need to figure it out.
Yes, Judge, if we could use that 14th, take a little bit of time, but.
All right, November 14th will be the next hearing at the defendant's request.
Months from today, 11, 14, 10.
Oh, God, can you give me a couple of phone numbers to call?
Thank you.
Okay, yeah.
State of Ohio recalls Ricky May at the Lawrence County Jail, case number CRB 25-185, A and B.
Okay, we probably need Mr. May on the telephone. All right, Mr. May is back on the teleconference. He does not have a lawyer. He says he's hiring Mr. Dwyer, but it hasn't happened yet. We're here on the issue of bond, and my main concern was care and custody of the minor children involved.
Your Honor, I
The prosecutor
texted,
was going to do a little investigating on that.
and I texted you the response from Children's Services.
Oh, okay.
Yes.
Okay. Well, I'm going to read this into the record so these folks can hear it also. This is a text from someone at Children's Services.
Yeah, I know the first name, it's Elena. I don't know her last name.
I just received this case on Friday. I do not have a report to give the judge. I can tell you that I went out to the house on Friday when Ricky was arrested for violating the no contact order. I had attempted to go to the home without police and saw the 4-year-old in the window. I could not get an adult to come to the door, so I had to call law enforcement. However, it was determined Haley was in the home with the child. Who's Haley?
Me.
You? Okay.
Yes. The doorbell was turned off. We have a thing that anytime the door opens, it chimes. And it was turned off, so I did not hear it ring, and I also did not hear her knock. But I did speak with her afterwards, and she was aware that I was in there the whole time.
I can tell you that I did a drug screen of them all on Friday. I do not have those results back yet. I have no information at this time other than the house on its own was not concerning for living conditions. Based on my initial contact with the family, I will be making recommendations for services that the family will have to implement in their home. However, I haven't had enough contact with the family to tell you at length what those services are. That's it. Okay, well, that's kind of concerning. Let's set it for another hearing Friday, and hopefully Children's Services will have more information then. Have you folks been in contact with Children's Services?
Yes, I have.
Okay. Well, I would encourage you to continue with that, to stay involved. And I'll set this back for a hearing on this coming Friday, which is the 17th. And we'll set it as a pretrial. Hopefully, Mr. May will have a lawyer by then. We'll have more information from Children's Services. And make sure these children are taken care of.
Your Honor, I'm begging for independent help to protect my grandchildren. I'm begging.
Well, Children's Services is involved. I mean, that's about all I can do. I don't have authority to, they don't answer to me. They answer more to the Common Pleas Court. They're an independent agency, but they will give us information. And I'd like to have it passed on to them that it's set for Friday for an additional hearing, and I would like to have more information about the status of the children then. If you feel like there's more of a criminal problem, you can go file a complaint with the sheriff's office. I would suggest also that you've already done this, stay in touch with Children's Services.
I'm sorry, I couldn't hear you.
Stay in touch with Children's Services also.
Yes, sir.
Be back here Friday, and we'll, it's open to the public. You're welcome to be here to see what additional information is gleaned by then. Anything else, Mr. Healy?
Well, I'd like to readdress the issue of bond, Your Honor, and the recommendation that we made previously, I was not taking into account the fact that this is a probation violation. And I think it's just based on the allegations, it's pretty clear that he was not reporting for probation. He was found to be in the presence of the young lady in which there was a protection order in place. And he has another charge pending involving another person who he was.
I said that $25,000.
Well, I just don't think I just think that under the circumstances, I've asked the court to not set a bond. It's a probation violation. I think that the court can do that. And I realize we'd be coming back on Friday. If the court sets a bond, we'd also want a GPS monitor.
Okay, I will add the GPS monitor, but I think I have to set a bond, in my opinion, on this type of case. So I'll keep it at $25,000 cash assurity with a GPS monitor in place, ordered to stay away from your name, ma'am?
Haley.
Haley.
Yes.
And be back here on Friday the 17th at 10 o'clock for the next hearing. Okay, that's all.
Thank you.
State of Ohio versus recalls John Pennington, case number CRA 24664, PRD 2418.
Your Honor, I spoke with Kathy Ross from LCR, and she said Mr. Pennington left on September the 12th, and she's going to refax over a discharge letter as well. We believe that he's at Recovery Ranch, so I'll try to reach out to someone and ask them to bring him in.
Okay. I'll go ahead and issue a warrant today for non-appearing and leaving treatment.
Thank you, Your Honor.
Thank you for the report.
You're welcome.
Your Honor, the only thing we have left, we're waiting on a urine screen.
Yeah, we've about a dozen times. I don't know if she's ever going to get it, but she drank water and I think she's just got stage fright, to be honest.
Okay, court will be in recess till we get